Welcome to SQE1 Preparation, Criminal Practice, No Comment and Adverse Inferences by Street Lawyer, helping you to pass first time the SQE1 assessment. And for those who are interested to educate on the criminal law and criminal practice, this one specifically about the police station. The FLK Criminal Law and Practice specification refers to advising the client, including vulnerable clients, whether to answer police questions, adverse inferences, and the right to silence. So what key knowledge is covered in this class? Well, we're going to focus on the right to silence and adverse inferences, understanding the right to silence and the role of adverse inferences, the conditions for when an adverse inference can be drawn from a defendant's silence, and legal privilege and written statements, knowing when legal privilege applies and the importance of written statements. By way of an SBAQ tip, this could centre on the circumstances when an adverse inference may or may not be drawn. So pay attention to one of the slides that relates to R versus Argent case, and whether a suspect can rely on legal advice to remain silent and prevent an adverse inference being drawn at a trial. Again, a very important SBAQ type style question. We now move on to test your knowledge 1, which is a set of true or false questions. Question 1, true or false, an adverse inference can be drawn if a defendant fails to mention relevant facts during a police interview that they later rely on at trial. Question 2, true or false, if a defendant does not have the opportunity to consult a solicitor before police questioning, an adverse inference cannot be drawn from their silence. Question 3, true or false, if a suspect hands in a written statement that covers all the facts of their defence, the court may still draw an adverse inference from their silence. Question 4, true or false, a solicitor may advise a client to remain silent during a police interview if the police have not fully disclosed all evidence to the client. And question 5, true or false, a defendant can prevent an adverse inference by claiming their silence was based on legal advice alone. Moving on to test your knowledge 2, which of the following best describes a position regarding whether adverse inferences will be drawn from Tony's silence at the police interview. As Tony relied on the advice of the solicitor to remain silent, adverse inferences must not be drawn. If the jury is satisfied that reliance on the solicitor's advice was genuine and reasonable, inferences may not be drawn. Or is it 2? As Tony remained silent at interview before charge but put forward a positive defence at trial, inferences must not be drawn, irrespective of reliance on legal advice. Or is the answer 3? As Tony relied on advice of the solicitor to remain silent, adverse inference may not be drawn if the trial judge is satisfied that reliance on the solicitor's advice was genuine and reasonable, inferences may not be drawn. Moving on to the content then. Question, what is the suspect's right to silence in a police interview under caution? A suspect has the right to remain silent during a police interview under caution. Suspect's never going to be compelled to answer police questions. However, under Section 34 of the Criminal Justice and Public Order Act 1994, silence may lead the court to draw any inference that may appear proper from a suspect's refusal to answer police questions if they rely on facts not mentioned during the police interview. And that might include an adverse inferences at trial if the suspect later relies on facts not mentioned during the police interview. See the case of Condren. Question, what then is an adverse inference? An adverse inference is a negative conclusion that the court may draw about the defendant's silence during questioning. That's police questioning. For example, the court might infer that the defendant remained silent because they had no credible explanation at the time and their subsequent defence at trial is a recent fabrication. Check out R versus Cohen, R versus Beckles. So question, when can the court draw an adverse inference? An adverse inference can be drawn if the defendant fails to mention a fact during the interview that they later rely on in court. An adverse inference may therefore arise from any no comment response or a failure to disclose any key details relevant to their defence. And check out the case of R versus Betson Hall. Then the next question is what are the preconditions before an adverse inference can be drawn from a defendant's silence? there are 5 mentioned here. Some textbooks mention 6. Criminal proceedings need to begin. But let's just look at the first one. The first one is interview under caution. The interview must be conducted under caution. Second one is reliance on undisclosed facts. The fact that the defendant did not disclose must be one they later rely on in court. And then 3 is silence before charging. The silence must occur before the defendant is formally charged. 4, questioning about the offence. The questioning must aim to establish whether and by whom the alleged offence was committed. And then number 5 is, condition 5 is reasonable expectation. The defendant could reasonably have been expected to mention this fact during the questioning. And the case that's relevant there is R versus Argent. Question: can an adverse inference be drawn if a suspect hands in a written statement? If a written statement covers all the details that the defendant later relies on at trial, no adverse inference will be drawn. And the example was given in R versus Knight. The Court of Appeal confirmed that a prepared statement suffices if it includes all relevant facts. The question is did it include all the relevant facts? Next question is when solicitors may advise silence. Well, that could be for a number of reasons, but 3 are given here. Insufficient police disclosure is 1. If police disclosure is insufficient for proper advice. Second one is complex cases. If the case is complex and immediate response, it may be risky to talk. And then situation 3 is vulnerable suspects. If the suspect is vulnerable, unwell, or under distress, silence may be recommended to protect their interests. And check out the case of R versus Roble, Howell, and Argent. Next question is can a defendant rely on legal advice at trial to avoid an adverse inference? This is very important. You could well get an SBAQ question on this. Can a defendant rely on legal advice at trial to avoid an adverse inference? Reliance on legal advice does not automatically prevent an adverse inference. However, if the defendant reasonably and genuinely relied on legal advice, the jury may consider this in determining whether silence was justified. And check out the case of R versus Condren versus UK and R versus Beckles. Question is waiving legal privilege. How can a suspect avoid an adverse inference? Well, first point to note is that legal privilege allows a suspect to keep communications with their solicitor confidential. However, if the suspect discloses reasons for legal advice in court to avoid adverse inferences, privilege may be waived, allowing cross-examination on the advice given. That means a solicitor might be called to give evidence. Next question is when adverse inference cannot be drawn, and the situation arises here is no adverse inference can be drawn if the defendant was not afforded the opportunity for legal advice. That's in section 58. An example of this is in cases where police delay legal access for a suspect. Silence during interviews cannot lead to adverse inferences. And again, check out cases of Condren versus UK and R versus Argent. Now going back to these test your knowledge questions, please pause the slide, check out the answer and move on to the next slide. Then finally test your knowledge 2, pause the recording, check your answer and move on to the final slide. Please re-watch the whole video. Remember, watch all the videos in the SQE Prep Criminal Practice series. Understand the functioning legal knowledge being examined by reading the SRA website for yourself. Revise from a really good SQE book or books. Attend and participate in the classes. Prepare Q&A flashcards, which is a great idea. Practice as many SBAQs as possible. Subscribe to Community Legal Education. Put your notification on so you don't miss out on more SQE prep videos. Hope you found this class useful. If you've got any questions, put them in the chat box. See you in the next class and thank you for watching.